Hello, everyone, and today we're luckily joined by John Uustal of the Kelly Uustal firm in Fort Lauderdale, Florida. John is a superb trial lawyer, graduated of Georgetown University School of Foreign Service, the University of Miami School of Law. I know he practiced at the Schlesinger firm until about 14 years ago when him and his partner, Robert Kelly, opened the firm of Kelly and Uustal. I know he wants to get top billing, Bob. But John,
That's
great
right.
to have you with us here today.
Thank you. It's great to be here.
I want to ask you a few questions before we begin. What was it in your life that led you to want to be a trial lawyer?
Well, after I went to law school, I really didn't know what kind of lawyer I wanted to be. And I was lucky enough to get a clerkship with Judge Fay, Peter Fay, on the 11th Circuit Court of Appeal. And just, he was a federal judge appointed initially by Nixon and then elevated to the appellate court by President Ford. And he had been a trial lawyer. He was probably the best trial lawyer in Florida and one of the best in the country in the 60s, even probably going back into the 50s. And so, she just told stories, and they were just, about getting justice for regular people in the courtroom. And I just thought, wow, I don't know if I can do it, but I'm going to try. That's what I want to be.
I think it turned out okay for you.
Yeah, that's true. That's true. I got lucky because I'm not sure I would have succeeded in other areas of the law.
Oh, I think you'd have been fine in anything. But not only are you involved in the law, but you've authored one book. You have another book coming out. Is that right?
Yeah, hopefully shortly after the new year, although it's a little delayed. But yeah, I have a book coming out called Corporate Serial Killers.
Tell us about what's involved in lawyers writing books. I mean, it sounds easy, but I know it's not. Tell us about what's involved in doing something like that.
Yeah, I thought it would be easier than it turned out to be for me. We write as lawyers. We do a lot of writing. It's definitely a different kind of writing, but I've always loved books. I did writing. I did playwriting and script writing before I became a lawyer, so I thought that it was something that would come easy to me. But it's hard, because pretty much a lot of things that happen in law school train us to not speak clearly, and then when we become trial lawyers, we got to learn how to speak to regular people again. Well, it's the same way in books, but I guess in terms of my writing, I hadn't perfected. I'm not saying I've perfected it now, but I've worked really hard to make an engaging story that flows smoothly, that's emotionally involving and easy to read.
Well, when you're thinking about your cases and you've done your discovery and you're getting ready to go to trial, I would assume that you're thinking of it kind of like a book or a movie. What's the story you're going to tell in the trial? Is that how you approach the trials?
Absolutely. It's interesting that the trial's kind of like you've written a play, but you've got another playwright over there interfering with your play every so often and trying to write a different play. So, trials are fascinating in terms of storytelling because you have to win a battle of storytelling in a way. You have to find the truth. You have to show other people the truth in a way that's emotionally engaging and that they'll listen to. It's harder. It's much harder because you have someone fighting you in some ways, but in other ways it's easier because the day's done when the day's done. With a piece of writing, you're like, oh, I can make it better. I can make it better. I'm going to make it better. And at some point, the day has to end.
Speaking of that you want to make it interesting, when you're in a trial and you're giving your opening statement, are you going to give up everything in the case and just lay it all out? Or are you going to hold some things back that you may think will interest the jury later as you go on in the trial?
So it's interesting you asked that because I just served as a juror about 6 weeks ago for the first time in my life. And that changed my thinking on that question. Before then, I always wanted to have some things that it wasn't necessarily because I wanted something interesting to happen later in the trial that the jury didn't know about, but it was that if I had developed my case right, the defense didn't always know where I was going. And so I wanted that to play out as a surprise to them. So I usually hold things back in opening. But I'll just add that since I served as a juror on a 5-day case. We had, by the time that we were sworn in and to the time we were deliberating, it was 2.5 days of evidence. And I couldn't remember all the evidence, right? So I'm sitting there thinking, I asked her to sit there for a month sometimes longer. And if I can't remember the evidence in 2.5 days, because I didn't necessarily know what was important as the evidence coming in, I didn't have the context for it. So now I believe that, and I've told all my partners that we really have to work on this. It is critically important. In my mind now, the most important thing to do in opening is to provide the context for the evidence so that the jurors actually know it's important when they hear it. Otherwise, they're not going to hear it, and they're sure as hell not going to remember it.
That's a great point. I hadn't really thought about that quite as much, but we're so engrossed in the case that we kind of lose sight of the big picture, and we're into the minutia where the jurors are into perception and the big picture, I think.
That's exactly what it was. And as a bystander, because for the first time in my life, I'm just sitting there watching, I could see the lawyers doing just what you said.
Now, I've heard about and read about the unique things that you do in jury selection. Can you share some of those with our listeners and ideas that help you to really unearth as much information appropriately as you can before you select a jury?
Yeah, it started just with the general idea. I used to work at Sheldon Schlesinger's firm. I know your old partner, the old school lawyers had this idea, or at least that's what I was taught, that, it's over after the jury's sworn. So we hear that, but Bob and I, when we started our firm, we really said we believe it. So what does that, let's take it to its logical conclusion. Do we put every bit of effort we can into jury selection? And we thought, well, no, we could put in more. We could have more people in the courtroom, each with their own job. We could try to plan beforehand to organize the information. So one of my problems that I would have before we started our firm when I was trying a case was try to consolidate all my impressions and all my notes and all the other people's notes in the short time that the judge was giving you to think before you exercise peremptory. So can we make a system to organize that? And then, so as we're putting all this time and energy and thinking into this system, only about, 11 years ago, the iPhone came out. And it just started to change everything. There was so much information available about people that's not private. It's not hidden. They're putting it out there for people to see. But, and gradually it became clear that the various rulings of the Bar Association, not only do you have a right to do it, some judges have said you have a duty to do it. You're not doing your client a service. You're not really being an effective advocate if you leave some information out there that you don't have. And so we've basically put together the specialized team at my firm in every trial. They're there. If most of our trials, we can go overnight, and sometimes there's even 2-3 day jury selections, but it's actually harder if you have a 2 or 3 hour jury selection, because you got to get it all done after you get the names. But we have a whole team. We have special uniforms so that because everyone else in the firm is not in trial is going to try to bother them. And I can go back. We don't have time now, but we can look at specific cases and we say, you know what, that verdict wasn't as high as I thought. Or we try a lot of cases, so sometimes we get a loss. Well, what happened? And usually, if we dig deeper, there's something that you could have found out there in social media that a juror was telling you, potential juror, and that we didn't pick up. So after that happened, we went and did an after action after a trial, found something on a juror. And basically, what I say now in our office is, to the lawyers, you can lose your case while you're at home in bed at 3 a.m. at jury selection because there's someone in the office who's not properly trained, and they stop looking before they should. So we now train our people, we only have a few jurors per person. Really put in all the resources you can so we have all the information we need when we're making the decision.
Oh, that's fantastic. I'd like to talk to you about two cases. First, I'm going to go to the one that it's not one case, but it's a litigation in Florida after the Engel case. Many lawyers in Florida, including your firm, got involved in tobacco litigation. Some were involved before, but individual cases for individual smokers. First of all, tell us about the Engel decision, how it affected the practice, and how your involvement has been in tobacco litigation. I'm going to preface this by my understanding is many cases settle before trial, during trial, after trial, on appeal. Tobacco cases don't settle. They're paid when this U.S. Supreme Court denies a petition for cert or they rule on the merits. Is that right?
That's right. That's right. And, we got into tobacco litigation soon after starting the firm, and we did not appreciate the business ramifications of what you just said. You're going to try every one of them, and some of them can take over a decade or longer before you get paid, even if you win, and you don't win all of them. And then some of the ones you win, you lose along the way on appeal because these are phenomenal lawyers that tobacco has hired. The way Engel came about was there was a class action that was tried in Miami in the late 90s. There was a verdict for the plaintiff. Gradually, it went through the appellate process, and the Florida Supreme Court decertified the class, but said that there were certain findings for these class members, which was a very specific group of people that were diagnosed between 1992 and 1996.
So that's it. It's only in that window. I didn't know that.
Yes.
92 to 96 are the only smokers in the class that can bring an Engel case.
That's right. So when they bring a case, they have a couple of things. You have to remember that back then the tobacco companies didn't admit that smoking caused any illness or was addictive. So the finding by that jury in Miami in 1999 that smoking was addictive and caused certain illnesses was initially a powerful weapon to use that you didn't have to go through and prove all that, because it takes a fortune to go prove that smoking causes illness. So you had that, and then you had that the cigarettes were defective, and that the tobacco companies had committed a fraud. So those were you don't have to. You still kind of have to educate.
They tell the jury that this is decided.
Yes. So
that doesn't mean they're necessarily going to automatically rule in your favor.
No, because it's really probably we honed our skills on jury selection in tobacco cases because not only because you have to try them all, but because it's kind of jury selection in a extreme circumstance. So in most cases, people have views that may affect how they look at the evidence. But in tobacco cases, people generally fall into one or two categories. They focus on the evil that the tobacco companies did, and they say, I'm not going to let them get away with that. Or they focus on the fact that the smoker continued to smoke after they should have quit, and they say, I'm not going to make them rich. So, depending on who you get on a jury, there's some tobacco cases you can't win, right? They just say, I don't care if the law says that if they're both responsible, I have to find against the tobacco companies and award a certain amount of money to the smoker. They're going to disregard the law. Every one of these cases should be won, but a lot of them are lost because they're disregarding the law because they don't want to make somebody rich. And you can understand why. There's a strength to that. I mean, there's a truth to it that people shouldn't, once they know they should have quit, and they shouldn't get a lot of money because they didn't quit. It's not the law, though. The law is if you do something really, really evil, I mean, it's wrongful. It's fraud, and to the level of you're killing people, but when you're committing a fraud, then even if they're partially at fault, you're still responsible for your percentage of the damages. That's our law in Florida. So anyway, we started litigating. The first case, I didn't try it. Bob Kelly, my partner, tried it. My first case was with Bob when I was a very young lawyer, and that's what we were talking about before we began. And Bob's book, The Memorandum, is coming out about that trial, which is a fascinating.
We're talking about that next.
Okay, so he tried that without me, and he got a $300 million verdict, which was reduced to $40 million by the trial judge, and then it was reversed eventually by appellate courts. And then it had to come down, and then I retried it. We got a good verdict. We had four, by this time, unfortunately, by the time we retried it, the plaintiff, who had been trying to get enough money for a lung transplant, she was already terminal. So, and she died right after the second verdict. Then there were 4 different appeals, just in state courts, up and back down to the trial courts. Eventually, through the Florida Supreme Court to the U.S. Supreme Court, and it was almost a decade before that case was paid. So, you know, there's a famous, at least in the people who do tobacco litigation, there's a famous memo that one of the tobacco companies wrote, where one of the executives was writing to the lawyers, and he said, "Look, to paraphrase Patton, we win these cases by spending all our money. We win these cases by making the other sons of bitches spend all of theirs." And so, you know, you have cases that cost so much, and you know, they don't get paid even when you win for so many years. It could destroy your firm.
No, it's a tough gamble, and somebody's got to do it and hold these people accountable, and that's what you all have been doing. So let's talk about how we met. I believe it was in late 1998. You were handling with Bob Kelly in your old firm. I think it was an Oldsmobile station wagon. Is that right?
That's right. You got a good memory.
It was an A-body car manufactured by General Motors. And we, out in California, had a similar case, A-body Malibu. You came out, looked at some of the information we had. Then you went to trial. I believe 38 million verdict?
It was a $60 million verdict.
Yeah, I'm sorry about that.
Well, it got reduced by the judge for comparative fault to 33, but the appellate courts actually
reinstated it.
Reinstated it, exactly. So it's 60 million in the end.
And then they went through that. But let's talk about the case a little bit. And you did mention that your partner has written a book. I've read The Galleys. They were kind enough to send it to me. It brought back a lot of memories to me. Right. And names that I had forgotten from General Motors, some of the in-house people. But tell us about that case and that litigation and what was so great. And you said that was your first trial ever?
My first trial, yes. 6 months.
It's all downhill since then.
Yeah. I mean, it was formative for me. You know, it was like a crucible. That litigation was very just all-consuming back then. People don't remember back in those days, you had the CK pickup trucks exploding. You had, there were people literally burning alive every day in GM vehicles. And so we felt like we were doing God's work, trying to save not to jump ahead, you got that verdict that probably convinced them soon after ours, that probably convinced them to change their design. So, but at the time we were doing the work, we felt like we could make a difference. We could get them to change their designs, and it was literally going to save people from burning to death in those cars. But everything was a fight, and there was so many secrets. One secret would come out by one lawyer. I forget who the first guy was when the IV memo was produced by mistake, and we thought that was the end of it. But then there was document after document of more fraud.
Well, tell it. What is the IV memo?
So GM there is a memorandum authored by an engineer named Ivy.
Edward Ivy,
and it calculates how much, as he says it in the memorandum, the Ivy report, that it would be worth $2.20 for GM to prevent all fuel-fed fires in their vehicles, future vehicles. So he's basically doing a calculation, and coming up with how much it would be worth for GM to.
Well, and I think the way that he did that is he took how much they're paying on cases wrongful death. I think it was 200,000 versus the number of cars on the market versus the fire incidents, and divide it out, and you come up with, if you spend, even better, if you spend $222.20 to fix the design, it would be cheaper to fight the lawsuits, is basically what he said. But that was just the beginning, and that had been around for years. Then I believe in your case, and it's coming back to me now, it's only been
Right.
20 years, that your judge allowed to be produced memorandums where Mr. Ivy, finally a plaintiff lawyer, got the memo. Then they went to take Mr. Ivy's deposition. Of course, he says, I did it on my own time at lunch. I never showed it to anyone. Well, then, and correct me if I'm wrong, but I think it was in your case that you found out that he had been interviewed by lawyers before depositions, and they had written memorandums basically saying a lot of what he's saying wasn't true. And the judge forced them to be produced to you under the crime fraud exception to the attorney-client privilege, which is another huge showing. And those memorandums further evidence the cover-up that was going on and what General Motors was doing about it. Tell us about how that came about.
Yeah, wow. Those were some like moments that just were thrilling to watch as a young lawyer. So the Ivy memo, even though it had been produced by mistake by GM, and so it was out there, it had never been admitted into evidence because Ivy testified that no one had ever seen it, and he had just done it for himself. So I was just on the internet. This was in the infancy of the internet. People might not understand what it was like in the 90s, but I came across a case. It wasn't in Westlaw, but it was just somewhere reported. I don't even remember that. And it said, a judge was saying that some document was going to have to be produced, and he would, because of the attorney-client privilege, he would redact part of the document, and he would redact it from this part to the sentence that says how much Ivy said that Oldsmobile could spend on fuel systems. And I said, wow, this is the document where they're interviewing Ivy about the very things that we need to look at. So what I didn't know at the time was that order had been vacated by the Fourth Circuit. So the GM had actually settled the case right after the order was entered, and then somehow Ken Starr came in as their lawyer while he was.
Was that the South Carolina case?
Yeah. So he got the Fourth Circuit on an already settled case that was moot, and you would think, to reverse that order. But I didn't know it. So I went to our judge and said, look, it's already been produced. Produce it. And, you know, their thing, they pretend to produce it. They don't produce it. The box doesn't have it. They just considered court orders to be advisory back then. But eventually we got the document, and within about 4 hours, they had some people. I was in Detroit at the time. Bob and me were taking depositions in the Ren Center back in, you probably took some there.
Too many.
The yeah.
The Renaissance Center, downtown Detroit.
Exactly. So all of a sudden, about 10 guys walk in with suits, and I didn't even know who they were. And they said, look, we gave it to you by mistake. It had never been produced. We didn't realize that. We want it back. Long story short, our judge ordered us to give it back. But we then requested or subpoenaed GM to bring certain documents to trial. Our trial judge ordered them to give it to him. The guy comes, the GM lawyer comes without the documents. He threatens to put him in jail for the weekend. The guy says, all right, I'll get you the documents. He hands the documents to the judge. The judge reads it. And now he's had about 3 months of trial. He knows their defense and everything they've been saying. And he reads it and he just says to the GM lawyer, what am I supposed to do? Just sweep this under the rug? And the GM lawyer says, yeah, that's what the law requires. And so the judge says, I never had a moment like this in the courtroom since. The judge says, you know, some of us still believe what's written on the courtroom wall. So everyone turns to, because, you know, you can see it every day.
Right.
You don't remember what it says. And it says, we who labor here seek only truth. And we all look at it, and he says,
No.
it's coming out. Yeah.
And that was obviously instrumental in not only your case, but in my case. And I will be the first to say that your help, not only you and Bob and Shelley Schlesinger and your firm, was instrumental in helping us get our verdict. And we couldn't have done it without you. But I think that is what plaintiff lawyers do, is they share with one another, not only documents that you're allowed to, but ideas and strategies to help others be a success. Talk a little bit about that and why that's important.
Yeah, so that litigation is the perfect example of that. We cannot win. The big corporations, the way their current litigation strategy is structured, and it was probably developed back then in the automotive litigation, we will lose every case if we're just operating on our own, because they can successfully hide enough in each individual case that you can't get a full picture of the truth. So in that situation, somebody got the Ivy memo by mistake. I think it was a guy in Corpus Christi, his name.
David Perry.
Yes, I think it was Perry who got it. So then he gets that document comes out. Then we follow up and get, Kendall Few and
Kendall
Jim
Few
Butler
in South Carolina.
Yes, they got a list of a bunch of documents. Their judge ordered these documents to be listed in an attorney privilege log. And then GM settled that case. And then I came across that, saw those documents, requested them. We got some of those. Then Bob, because our judge ordered the initial document return, Bob went and saw all the other documents I think he called Kendall or Jim up, and they gave him the list. I don't remember that exactly, but somehow he got that. It might have been produced by GM, but he probably called one of them. Either way, it was something that they had gotten created. And then, so we were able to request those documents be brought to trial. And in the middle of our trial, the judge had, it was actually a different judge at trial than pre-trial, but he now understood the entire context and the real meaning of these documents. And so he put them into evidence. Then you guys got that, breathtaking verdict shortly thereafter with those documents going into evidence.
They were critical in the large punitive damage verdict, no question about it. What I remember about your case is when we won our case, they had a big story in the news, but they showed the videotape. I don't know if you can remember, of your incident happening, and with people in the background screaming and saying, "Oh my God," and as the car goes up in flame and the family is in the car. Do you remember that?
Yeah, it was just strange. A passerby started videotaping. It wasn't like today. That was rare.
Very rare.
That
but it was pretty powerful.
Yep. Horrifying.
So then tell us a little bit about the tobacco litigation. How many cases have you tried?
I personally tried 2.
How about your firm?
Probably 20.
Wow.
Yeah.
And how many of those are you able to win?
So we have, including, some of the verdicts are, I hate to say this outside the tobacco litigation, but in tobacco litigation, $1 million verdict is a rough verdict because the amount of time, the amount of cost, but if you include those verdicts that are on the lower side, we've won a little over 80%.
Wow.
So then sometimes they get reversed on appeal. And
so you got to do retrial. The 20 trials of tobacco, I mean, has any firm tried more in this country?
Maybe, but I don't know.
You're in the top of it, aren't you?
Yeah, I'm not sure, but the 2 judges who have tried more tobacco trials than anyone are both in Broward County, Florida, which is where we try most of our tobacco trials, not all of them. So we might have the most. And they just we kind of it rotates through partners because they just take so much out of you. You
need a break. You need a sabbatical.
Yes. Yeah.
So tell us just generally what kind of other cases besides product liability, tobacco, is your firm doing now?
We do medical malpractice, product liability, tobacco. We have some commercial contingency. We've done a few banking class actions and things like that. But basically, we consider ourselves, we try to be true to the old time trial lawyer, you know, a catastrophically injured person who needs, you know, a miracle, and they're only going to get it in a courtroom. And that's the type of case we want to work on.
Well, listen, it's been great to have you. I met you as a young lawyer, and you cease to amaze me how great you've done, both in the courtroom, writing, and just to being a great person. And your firm's a great firm, and we're just honored to be able to visit with you here today, John. Thank you so much.
Thank you for saying that, and I'm glad I was able to do it.